Good morning, Mr. Mason, whenever you're ready.
Good morning, Your Honor. Thank you. May it please the court, my name is Mark Mason, represent the Florida Department of Highway Safety and Motor Vehicles, the petitioner. In this case, I'd like to give 3 minutes for rebuttal.
All right.
This case all started with Mr. Chakrin's conviction for DUI manslaughter. This resulted in incarceration and release in 2014. 5 years after that happened, now we're in February of 2019, he requests a hardship license hearing. Now his driver license was permanently revoked pursuant to 322.28 sub 2D of the Florida statutes. It's required anytime there's a DUI manslaughter conviction. But no one's out of luck. They can get a hardship license for business purposes only after 5 years of no driving and certain other requirements I'll get into in a second. So the hardship license occurs, and during this administrative hearing, the petitioner, or excuse me, the respondent, Mr. Chakrin in this case, he admits to consuming a beer a week prior to the administrative hearing. So on this basis, the application for a hardship license is denied. That's based upon a statutory requirement that an applicant remain drug-free for a period of 5 years prior to the hearing. He'd be eligible to reapply in 2024, 5 years after that date where he admitted to consuming the beer.
Haven't we already decided this issue in the Abbey case?
That's my argument, is that Abbey is one of these rare cases we have that is binding, that is factually and legally indistinguishable from what we have in this current case. Walsh as well, out of the first DCA, same thing. What the circuit court held, though, was that these cases are no longer binding law. And the sole basis for that was an amendment to the Florida Constitution, took place in 2018, that says that there's no more agency deference. Courts or hearing officers ruling on issues of general law are required to review statutes de novo. Now, Abbey, Walsh, literally any piece of case law where you have an instance of a state agency interpreting a statute it's charged with administering, that piece of case law is going to reference agency deference if it's prior to that statutory or the constitutional amendment. It's going to. So obviously, Abbey applied the law as it existed at the time. But the question is, does this amendment to the Florida Constitution, does this totally change everything? Can we revisit all of these opinions now that reference agency deference and say, well, that's no longer binding law. Now we're going to look at this anew and just going to say, well, I don't find that persuasive. Now, on that issue, this isn't a case where you have Abbey, this court, saying, well, but for agency deference, we would have held that the drug-free requirement would not include alcohol. There's no language. In fact, what the Abbey court says, what this court says is, quote, any other interpretation would be unreasonable. Meaning that if you define the term drug-free to exclude alcohol, that definition would be unreasonable. And that makes inherent sense because the hardship statute that we're talking about, 322.271, it's talking about when you have your license revoked because of a conviction for DUI under 316.193. And turning to that statute, you can get a conviction for DUI when you're under the influence of alcohol or a chemical or controlled substance. All Abbey did was apply that same definition to say, yeah, if you were revoked, if your driving privilege was revoked because of alcohol, it makes inherent sense to say that a requirement that you be drug-free include the very drug that led you to this place where your license was revoked and now you're seeking some form of reinstatement. Walsh similarly is directly on point. That involves specifically a person who was convicted of DUI manslaughter and then admitted at a hardship license to consuming alcohol. And what the court said there was for the circuit court to hold that, this doesn't include alcohol, ignores the common understanding that alcohol is a drug. That is a direct quote from the Walsh case. And they specifically say that, you know, looking at the standard of review, second tier cert review, what we have here is the departure from the essential requirements of law. Now, you could just basically swap out the entire language of that Walsh opinion, replacing the name Walsh for Chakrin, and you have the exact result in this matter. They're factually indistinguishable from each other, as well as the Abbey case. The Florida Supreme Court also, in Lesher, states in a footnote that to be eligible for a hardship license, there's a requirement that the person has been drug and alcohol free. Additionally, in my reply, and this was also presented in the circuit court, there was an administrative law judge who issued an opinion in a case called Iyer that contains a very in-depth legislative analysis, as well as an overview of Chapter 322, every statute that mentions drug or alcohol. And what it ultimately concludes is, yes, from reviewing all of Chapter 322, you know, maybe it goes back and forth about whether they're talking drugs or alcohol, but look at the legislative intent of this specific statute. Now, the Polestar statutory construction is always legislative intent. That's been confirmed by the Florida Supreme Court. And what the Iyer court said was the bill's sponsor back in 1990 specifically said, we're substituting the term alcohol for drug because drug is broader and alcohol is a drug. That's what he said. So the intention was always there that there be abstinence from alcohol as well as all other types of drugs, whether that's a chemical or controlled substance. Additionally, you have the statute 322.42. What that says is that the entire chapter 322 shall be liberally construed to the end that the greatest force and effect may be given to its provision for the promotion of public safety. Now, applying that means what we have here is someone who last time they drove a motor vehicle, they were impaired under the influence of alcohol, and it led to the needless death of another person. All I'm saying, all that Abbey or Walsh is saying, is that it makes inherent sense to apply this statute in saying that the very drug that led to that innocent person's death should be abstained from if you want reinstatement of the driving privilege. This is a public safety measure. It's not a penal statute. The rule of lenity doesn't apply here. We need to interpret the term drug-free broadly as mandated by statute. And in doing so, they said drug-free must mean abstinence from alcohol. Now, with regards to the statutory amendment, all it says is that there's no more agency deference. But I don't think there's a reading of Abbey, of Walsh, of Lesher, of the ALJ's decision in Iyer, where you can say that those hinged solely upon agency deference. In fact, they say the opposite. They say it would be an unreasonable interpretation to exclude alcohol, an absurd interpretation to exclude alcohol. They say that time and time again. And it's for the circuit court to hold differently simply ignores those portions of those opinions, all of which were not even cited in the circuit court order, much less discussed. So in this case, understanding that this is second tier cert review, and it's not the type where we're looking at this de novo, Walsh still held that in this exact circumstance, this is a departure from the essential requirements of law. What you're doing here, if you're the circuit court, is requiring the department to give a license to someone who killed somebody due to being under the influence of alcohol, and that, you know, giving a license to that person, even though they never abstained from drinking alcohol. It's the same exact situation here. This is one of those rare circumstances where you have case law that is binding and directly on point that simply was not applied at all by the circuit court. So for that reason, I ask that you grant this petition and quash the circuit court order. Thank you.
Thank you. Mr. Cozen, your video is off. Please turn it on. Mr. Cozen, thank you.
Your Honor.
We're ready when you are.
Thank you, Your Honor. When we were testing this system, and apparently still the video does not properly sync with the audio, despite Ms. Hayes' efforts, and she certainly deserves commendation for her efforts, that did not that did not work properly. So if the court would like me to continue with the video, I'll be happy to.
It's fine for us. I can hear you. I can see you. They line up. So please just go ahead and make your argument.
Your Honor, this is a second-tier certiorari review. The question before this court is whether the circuit court afforded due process and whether the circuit court applied the correct law.
And I think we're really focused on whether it applied the correct law.
It did not. I'm sorry. The circuit court applied the correct law. The counsel argues that it did not. Counsel essentially makes a public policy argument. This court decided Abbey back in 1999. The premise in Abbey, and I'm at page 1025 of Abbey, was that although drug-free is not defined in the statute, the department is the agency charged with administration of this non-penal statute. It is well established that the court should defer to a reasonable interpretation of a statute by the administering agency. That was true in 1999. However, in 2019, the Constitution Revision Commission proposed and the people of Florida enacted Article 5, Section 22 of the Florida Constitution, which provides that in interpreting a state statute or rule, a state court or an officer hearing an administrative action pursuant to general law may not defer to an administrative agency's interpretation of such statute or rule, must instead interpret such statute or rule de novo. Well, we need to look then, as the circuit court did, at the statute de novo. The circuit court, and I'm on page 7 of the appendix, page 4 of the original order, held that when a statute is clear and unambiguous, courts will not look behind the statute's plain language for legislative intent or resort to rules of statutory construction to ascertain intent. Instead, the statute's plain and ordinary meaning must be given effect unless it leads to an unreasonable or ridiculous result. Now, what we have here is a statute that says that an applicant for a hardship license must be drug-free. There is no real question about what drug-free means. If there were some question, we need to look no further than page 5 of the department's reply, wherein the department concedes that the drug-free language at issue was added to section 322.271 by chapter 90-102 laws of Florida. It is further noted that an earlier version of the legislation, committee substitute for Senate Bill 60, used the term alcohol-free instead of drug-free. Assuming that that is a factually correct statement, and I have no reason to believe it's not, the legislature, according to the department's concession, took out the term alcohol-free. We cannot put it back in. We must take the statute, review it de novo, and decide whether alcohol-free is part of the statute. We cannot add something to a statute that the legislature did not put there. Nor can we go back and reinstitute deference to the agency's interpretation of what drug-free means. We must read this under the present Constitution de novo. Now, counsel makes a public policy argument that this would set a good deal of decisional law on its head. That may happen. That could happen. That could be an unintended consequence of the adoption of Article 5, Section 21. But the supreme law of Florida is in its constitution, not in the statutes, and certainly not in the agency rules. We cannot step aside from the clear language of Section 21 of Article 5. We must, and agency hearing officers must, read the statute de novo. Now, in this case, the hearing officer did not do that. Referencing page 44 of the appendix, which is the final order denying early reinstatement, the hearing officer said, "You testified to alcohol consumption on or about 2/7/2019. Florida statutes requires 5 years of complete abstinence prior to consideration for early reinstatement. See below." Then below, the hearing officer purportedly quotes DUI manslaughter section 322.282D and section 322.271 paragraph 4. Quote, "must not have consumed any alcohol or drugs for 5 years prior to hearing." Well, that is not a correct rendition of what's in 322.271 paragraph 4. 322.271 paragraph 4 does not mention alcohol. So the hearing officer was factually incorrect. But then on top of that, the department now wants to argue that we should defer to Abby, which is no longer good law following adoption of Article 5, Section 21, and the cases following Abby, and the public policy that the department seems to think that Mr. Chakrin should not have a hardship license. So I would ask this court to find that the circuit court did afford due process and did apply the correct law. Specifically, the circuit court applied Article 5, Section 21, did a de novo review, found that the statute does not include the word alcohol, and therefore ruled that Mr. Chakrin had complied with the provisions of 322.271 and should have been afforded the opportunity to proceed with a hardship license. If the court has no questions, I will defer to counsel.
All right, thank you, sir. Mr. Mason?
Thank you again, Your Honor. Firstly, I'd like to address this notion that Abby's no longer good law, stating it was decided in 1999 and now it's been changed by this constitutional amendment. I would note that because Abby is such an old case that has never been overturned, it's actually very strong law. The US Supreme Court in Kimball, cited in my reply briefs, held that stare decisis carries enhanced force when interpreting a statute. We have a decision in 1999 that says drug-free includes alcohol. Legislature never once seeks any amendment to it, never decides to change that decision, even though all it would take was amending the statute to specifically only encompass, say, narcotic drugs, which was the preferred term offered by the petitioner or the respondent that frankly is just not within the statute at issue. Circuit Court also jumps to an online dictionary definition of the word drug, which neither party ever proposed. and just says, well, if you go by that definition, the term drug would be overbroad because it would include things like caffeine and aspirin. That's already been addressed in Abbey. What Abbey said was, no, we're not interpreting the term drug to mean, a caffeine or aspirin. We're interpreting it to mean those same mind-altering substances that can lead to a DUI. In this case, DUI manslaughter. That's all that Abbey was holding. We're not seeking to extend the definition of drug to encompass those other situations that would be well outside of DUI law. We're only talking about mind-altering substances. Now, the respondent also talks about we don't go beyond the plain meaning to say that drug means something different from alcohol. Well, I understand that that's the argument, but there's nothing that says drugs, the plain meaning of drug excludes alcohol. That's just the argument offered by the other side, but that's not a settled issue of law. In fact, if you go by the Walsh opinion out of the first DCA, it says that this stance actually ignores the common understanding that alcohol is a drug. That's a direct quote from Walsh. So in terms of not going beyond the plain meaning, if we apply Walsh, well, that means that alcohol is included within the word drug. Now, there was also a reference to page 5 of my reply brief that I somehow conceded an issue of legislative intent. What actually I said was that the term alcohol-free was substituted for drug-free. And then I go on to explain that this occurred during a 1990 legislative session when the bill's sponsor, Senator Gerardo, stated that drug was being substituted for the term alcohol because alcohol is a drug. All he was doing was expanding the definition so that it wouldn't only encompass alcohol, but would encompass all other mind-altering substances, i.e. chemical or controlled substances. Didn't concede anything. In fact, that legislative history is summarized in Iyer, and it specifically says in the Iyer opinion by the administrative law judge that the legislative history supports the department's interpretation as being consistent with legislative policy. This court made the same finding in Abbey that the legislative history supported the department's interpretation. So when all we have is a circuit court opinion that uses the term narcotic drug, even though it does not appear in 322.271, it resorts to an online dictionary definition of drug without even going into the legislative history. It doesn't cite Abbey, it doesn't cite Walsh, it doesn't cite Lesher, it doesn't cite Iyer, even though all those cases were cited in the response. All it's doing is offering a new definition of the term and ignoring the binding case law that states the exact opposite. This is one of those certain situations where you have case law directly on point. All those cases are not thrown out simply because there's no more agency deference. The court said any other interpretation would be unreasonable. That goes beyond just agency deference. That's the court making that determination. So I'd ask that you apply Abbey in granting this writ. Thank you.
Thank you. Thank you both. That concludes our session for today. So court is adjourned. Thank you.
Thank you.